So today we're going to do a bit of a specialist piece on tax and legalities all around divorce. And with me I have two experts in the field. So we have Paul and Henry. And Henry, can you just introduce yourself for a moment?
Yeah, sure. I'm Henry Venables. I'm a director and solicitor at Maguire Family Law. We're based in Altrincham, Wilmslow, Knutsford and Manchester. I head up the Knutsford office and I specialise in all aspects of family law, but predominantly divorce and financial settlements.
Okay, thank you. Very, very interesting and helpful. Paul?
So I'm Paul Brown and I'm the tax director here at an accountancy, and I'm responsible for pretty much all of the tax advisory work that we do here at the firm, and that extends everything from corporation tax, inheritance tax, income tax, capital gains tax, and pretty much every other tax you can think of.
Most of which I'm sure Henry comes across on a daily
Absolutely.
basis in your role, because it touches on virtually every aspect of tax.
Absolutely, but it's also something that frightens us as solicitors to death because we're not the experts on the tax. Paul is, we know the legal side of things, but we often need a lot of help and guidance on tax matters.
Yeah, and likewise, Paul and I are both very quick to say that we are not, we're not lawyers. We don't know the legal aspect of, there is so much crossover between tax and law. Tax law is a law in its own right.
Yeah, absolutely. But I think the trick in every professional services environment is knowing your limitations and knowing how far your expertise extends, and then knowing when you're going beyond that and having the right people to be able to call on to provide the specialist advice when required. So.
Yeah, absolutely. So that's why you're here today, Henry. Fantastic, thank you and welcome. So before I turn to some more specifics, we are coming towards Christmas 2024. At time of filming, I got Brian taking the mick out of me for saying filming. There's my Northern Irish that's coming through. It is today 19th, so 19th of December 2024, and I've always heard that post-Christmas there's like a Black Friday of the divorce world. I don't know whether it's the 6th of January or something like that, when I suppose all of the Christmas is worn off. I don't know, maybe people are putting on a good front, wanting to stay with the family and not spoil Christmas, or maybe, I don't know, the rows over the burnt cocktail sausages just got too much. Is that actually a thing, or is it just a rumour?
I think it's a bit of a thing. I think, like a lot of these things, I think the media quite like the strapline of it being busy time for divorce lawyers. I think, like a lot of things, people can sometimes put things off until the new year, whether that be moving house or getting divorced or whatever it might be.
Or going to the gym.
Or going to the gym, exactly. And then, come January, then people are motivated to sort of get on with things. So I do think there is something in it. There's reports, sometimes you read in the newspapers, that it's the day when the sort of credit card bill hits in January, or the first Monday when the kids get back to school, that's the day where people think, right, that's it. Christmas is over, New Year starts, I'm now going to press the button on a separation or a divorce, whatever it might be. But I mean, we're quite lucky that we're busy all year round, but there are certain times of the year, sort of autumn can be busy after the summer holidays. And again, January is also a busy time for us. But the reasons for that, whether it's because people get fed up with each other over Christmas, or more likely, in my opinion, it's just that people put things off till the new year and then start afresh.
Okay, interesting. So I suppose let's look at, there are some common watch outs, and I think things have changed quite substantially, and obviously tax is always changing. I'm sure the legal environment's always changing as well. I personally got divorced about 10 years ago, and I think there've been quite substantial changes in terms of the immediacy of things that need to be done post separation or post divorce. So I'm really interested to find out what you've got to say about this subject. And for the record, both Henry and Paul are happily married.
Perhaps until January.
So let's. I suppose I'm going to start off with some of the Well, let's just turn to that timing and tax. So, Henry, maybe this is more of a question for you. So, in terms of asset transfers, how important is the timing, or for either of you to answer this one, so relative to divorce or separation date, and how does that impact on the legal or tax responsibilities for both parties in a divorce situation?
I don't know whether you're better placed to sort of deal with the timing side of things, but
yeah, I think there are some quite, particularly in terms of that asset transfer piece, there's some quite sort of important timelines that people really need to be aware of in a divorce situation. I think in the sort of situation where people are, married, living together, and everything's going smoothly, then a husband and wife can transfer assets between themselves from a capital gains tax point of view without any issues. Once the separation has happened, there's a clock that starts ticking. In the old days, effectively, unless the assets were transferred in the same year that the couple separated, then there would be effectively a market value sale almost, or for tax purposes, the one spouse would be deemed to have transferred the asset to the other at market value for capital gains tax purposes. And
this was, am I right in thinking this used to be triggered by the tax year? So it wasn't correct. 12 months from doing separation. Exactly if you separated on the 30th of March, then you had 6 days.
6 days, yeah, exactly. So, which was clearly a ludicrously short amount of time, and so from April 2023 they've changed the rules, and now, absent a court order, and the court order kind of sort of overrides the general timing, and Henry can talk more about the concept of a court order, I'm sure. But essentially, if we don't have a court order, then now you've got 3 years from the end of the tax year to transfer the assets between spouses, and you'd still be able to do that on a tax-free basis. So it obviously gives a lot more time to actually make some rational decisions about this, rather than potentially ending up with a tax charge, because, as you say, you've separated on the 30th of March and you only literally had that 6-day period, which clearly it's impossible.
And it can take some time to come to an agreement, let alone to actually push transfers through a process.
Yeah, absolutely. So I think it's one of those changes of the law which is actually a real positive, and actually takes a lot of that pressure from a tax point of view away, certainly from a capital gains tax perspective anyway.
Okay, thank you. So before I ask you about court orders, has this anything to do with the timing alongside the no-fault divorce legislation?
Well, the no-fault divorce legislation came in April 2022.
So prior to that,
yeah.
Right. Because before that, if you wanted a no-fault divorce, you had to be separated physically for 2 years or something.
That's right, yeah. So you either had to rely on unreasonable behaviour or adultery, or if you didn't want to use either of those two reasons, you would need to wait 2 years before you could effectively separate. File for divorce without using a reason or to blame the other party.
Wow, so in those instances, before that legislation came through, that was just, there had to be fault in order for you to transfer assets with no gain.
Essentially. So people would be almost forced into filing
the blame
for
game.
Divorce. Yeah, the blame game, filing for divorce based on behavioural reasons, not because they wanted to, but perhaps from a taxation pressure point, which is a nonsense really.
Yeah, and that's pretty horrible. I'm sure that leads to a lot more acrimonious issues further down the line.
And the other thing perhaps to say is that I see a lot of clients who have separated for quite a few years before they decide to sort of formalise their separation. So people just, especially if they're amicable, they just separate, live separate and apart, but don't press the button on any sort of legal formalities around that, and they're quite happy just to have a period of time. For example, I'm dealing with a case at the moment where they separated in 2019, and only now are they sort of turning their minds to a divorce and financial settlement. So again, before the change in the tax laws around this issue, that would have potentially created a problem.
A huge tax issue for them, yeah. Absolutely, gosh. So talk to me about court orders and settlements, and how well, firstly, if you can explain what they are and what the difference is, and then how critical is it for couples to actually incorporate those financial settlements into some sort of court order, and how long do those court orders last?
Yeah, it's a good question. I mean, there's no obligation to have a financial settlement sort of ratified into a court order, and some people don't bother. They just sell the house or carve up the assets and just go their separate ways and don't involve a legal process at all. They may get divorced, which dissolves the marriage, but that doesn't dissolve the financial marriage, so to speak. The only way to sort of formalise the financial settlement is to incorporate that into a court order, and you can do that by consent. So you can agree the terms of the court order and submit it to the family court and ask a judge to approve it. You don't physically have to go to court and argue about it. But the advantage of having a court order is it gives certainty and finality, and nobody knows what the future holds. So to be able to cut all financial ties with your spouse could, or it usually is, advisable, because you don't know what your financial future looks like. So if your finances took off and went really well, and you hadn't got a court order dealing with the financial settlement, you're then vulnerable to claims from your spouse, even if you're divorced, actually, at a later date. So it's really important in the vast majority of cases where there's no assets at all. People sometimes take the view, look, there's nothing to deal with here, so let's just get divorced and leave the finances alone. But in the vast majority of cases, it's strongly advisable to formalise the financial settlement and have it incorporated into a court order.
Okay. And how long does the court order remain in place for?
It depends on the term of what's in the agreement. If it's what we call a clean break, where there might be assets transferring to one party or being sold, and there's no ongoing spousal maintenance or periodical payments being made, that's what we call a clean break. So it once the order is made and once the assets have been transferred and dealt with, that's it, and the order is legally binding, and there can be no comeback on either side. If there's ongoing spousal maintenance payments, then usually they're specified for a particular term. So it might be 3 years or 5 years or whatever. And in that situation, the order sort of remains live, as it were, until the term of the maintenance ends, at which point then there's a clean break at that point.
Okay, interesting. Let's talk about property, because quite often that is the big asset that a couple own together. Let's talk about their primary principal residence. Did I get that right, Paul?
Slightly, just about, yeah. I'll let you on.
So their main home, as I'd say in layman's terms. So talk to me about what tax implications there might be with a couple owning a home together, and if there's a mortgage on the home and so on.
So I think at the most basic case, I guess if one spouse, as part of the divorce, transfers their half of the property, let's say, to the other spouse, then provided we meet the requirements for a tax-free transfer, there's no tax issues at all. If the spouse transfers it and they've lived, in the property for the entire ownership period, again, there's no tax issues because it's been their primary residence throughout that period. Where it starts to get complicated is if one spouse moves out and then the property's sold down the line, because the principal private residence relief is dependent on that actually being your principal private residence. So if one of the spouses has moved out and then they jointly sell the property, it's conceivable the spouse who's moved out may end up with a capital gains tax charge because they've not occupied that property as their principal private residence for the entire period that they've owned it. Wow. Now there is a rule that says if you move out, you've still got the last 9 months of your ownership period is also treated as being as if that was your principal private residence. So it's conceivable. And if they've owned a property for 30 years and they're out of it for 6 months, you're talking about, small bit.
However, so, in Henry's example just now, if you've been out of it for 9 years, then there are issues. And I suppose then, Henry, is that something that can be looked at as part of the financial settlement so that one isn't particularly out of pocket in
Yeah,
terms
absolutely.
of tax?
I mean, that's what you've touched on there is exactly why we need input from tax experts, because part of the challenge in when you're dealing with a financial settlement upon a divorce is to establish what the asset base is and what that asset base is worth. But of course, we look to identify the net worth rather than the gross value. So quite often cases we deal with, there might be not just the main family home, there might be a holiday home or properties in other jurisdictions.
You've just gone ahead of me there. I was going to ask about
Yeah.
you give us a lovely scenario of a principal private residence, a main home, obviously owned jointly, and perhaps the couple is going to sell that and split the odds, but then maybe they have a property, a holiday let in Wales, although with current legislation and tax on properties in Wales and holiday homes and furnished holiday lets, maybe not a good idea. And then maybe a flat in London which they bought together whenever they were first married before they moved out to the country. What happens there? Because do they have to sell all three of them, or can you transfer one to one and one to the other and kind of almost swap? How do you work that all out?
Yeah, you can transfer. I mean, quite often it's very common, in fact, that there might be an acceptance that the main home has to be sold, because usually that's where the majority of the equity is kept. But there might be, whether it's financial or emotional ties to other properties, so one party might want to keep that property, which they can as part of the settlement, providing the numbers balance out. And again, this is exactly why the tax angle is really important, because what we don't want as solicitors is to oversee a couple or a client agreeing a deal only to find out later down the line that actually there's a big tax bill coming their way. So it's important to establish almost at the outset, or certainly before an agreement is reached, what the actual true net value of the assets are and what the tax implications are of a transfer or a sale, whether it's immediately or later down the line, so that the parties know exactly the true extent of the financial settlement they're signing up to.
That's really interesting. You've got me thinking about all sorts of things now, and I'm going to come back to that, but I'm just thinking, well, how do you do that with regards to a pension, for example, or a final salary pension? You know, because I suppose if somebody, and I suppose this is stereotypically, but often if a wife gives up work to look after children and genuinely has had a great career, gives it up to look after the children, and therefore doesn't have much of a pension, but maybe the husband has a huge pension potentially, you know, that and property, you can be very asset rich but cash poor, so it can be quite challenging, I'm sure.
Well, it is challenging, and pensions are a whole category of their own in terms of when you're looking at a divorce, and usually, not always, but in most cases, we will engage the services of an actuary to do a report on a joint basis, so report to both parties to sort of advise on the appropriate pension sharing order that should be made. And within that report, they look at the benefits and the income that the pension will produce in retirement, and that would include some tax advice as well. But you're right in that quite often, whether it's a husband or a wife, they might have different priorities. So again, without being stereotypical, a wife might think, well, I'm not that bothered about pensions, I'd rather have more property now or cash now. And the husband might think, well, I've been paying into that pension since I was 18, that's really precious to me, and I want a good lifestyle in retirement, and so the pension might be more important to him. And so then there can be a bit of a trade-off between.
Absolutely, and I suppose this is where it's so important to engage not just professionals who are expert in the field, but professionals who have seen this happen time and time again, and who can objectively, you know, describe and detail the potential pitfalls and the pros and cons of different situations and different answers, because people can get very stuck in either the now and what's right in front of them, what's urgent right now, and maybe not see the bigger picture.
Yeah, that's it. I mean, I'm sure Paul's the same with his clients, in that quite often I will say to a client in the initial meeting, what's your objective?
Yeah.
They might not know, of course, but you know, if it's important to ask at the outset what their at least initial objective is in terms of which asset they might want to retain or where they want to live, what sort of so that can then shape the direction of travel as to how you approach it.
Yeah, I mean, I think that's 100% right from my perspective as well, because too often people will almost become obsessed with the tax consequences, not just in this scenario, but more generally. It's actually, what do you actually want to achieve, and let's understand what the tax outcomes of that are at that point, and then if we can finesse that to achieve, the better outcome, which might involve some compromises, then absolutely. But let's not make decisions just based on, this is going to get us the optimum tax position in this scenario, because if you save a bit of tax now but end up owning a property which you really don't want down the line because that was the most tax efficient way to do it, short-term gain, long-term pain really in that scenario from my point of view.
So tax and divorce, two of the most emotive topics and situations to find oneself in.
Absolutely.
Right, I'm gonna whiz back, I didn't say circle back because that really irritates me, to the previous scenario there where we said about a main residence and a Welsh property and a London property. Any tax implications on those, Paul, that you can see?
Well, again, if you think about capital gains tax, it really does depend on the timing, and to go back to Henry's point, if there's a court order in place, then effectively, if the transfers are under a court order, then there's no capital gains tax to worry about here. If we're not got a court order, then we are into this. If it happens within, the 3 tax years following the tax year you separate, then it's fine from a capital gains tax point of view. After that, potentially you've got to value the half share that's getting transferred, and that might be a sale at market value as far as the capital gains tax rules are concerned. Happily, the stamp duty rules are fairly concessional in that effectively there's no stamp duty if a transfer of property takes place in connection with a divorce. It doesn't really matter when.
So you've got longer than the
you essentially, as long as it's in connection with a divorce, the arrangements that have been agreed as part of the divorce, then effectively the stamp duty is relatively benign in that situation.
Okay, that's interesting.
And I guess the other one is inheritance tax. And again, just to make life more interesting, there's different rules for inheritance tax as opposed to capital gains tax and stamp duty. So from an inheritance tax point of view, spouse transfers are exempt from inheritance tax. And as long as the marriage is still in existence at the time, so I guess the final decree hasn't been issued, as long as the marriage is still in existence, that will still be an exempt transfer from an inheritance tax point of view. But if it happens after, then it will be, from an inheritance tax perspective, a potentially exempt transfer, and you're into the whole conversation around the 7-year rule, and potentially if the person making the transfer dies within 7 years, that property's back into their estate.
Okay, so that's just sprung far too many questions, so let me see if I can distill one of them down. In that instance, am I understanding that if the divorce has come through and been finalised, and from a capital gains tax point of view, the two parties have 3 years to make those transfers to be exempt from capital gains tax?
Unless it's under a court order, when it's effectively unlimited time.
Okay, unless it's under a court order. But if it's just those 3 years, or a court order that says 1 year, 5 years, 3 years, if that transfer happened, say, 5 years post the divorce had been finalised, then the party dies 3 years later, then that's still in the estate on that side of the scale? That's
potentially still in their estate, yeah. So you're into the normal, once the marriage has ended, then you can't, the transfer is not exempt from an inheritance tax perspective. So if wife transfers half a property to husband, wife then passes away within 7 years, and that transfer took place after the marriage has ended, then yes, potentially that could get pulled back into the wife's estate from an inheritance tax perspective.
That's interesting. We've just had a not dissimilar situation from a client that we referred to yourselves, where the ex-husband died within less than a year of the divorce and had everything transferred to him. So
And I think
Interesting.
where you get to with that is, has there been a transfer of value as well? So I guess if it's a swap and they're broadly equal, there wouldn't be an issue because the wife's estate in that example hasn't reduced in value. But if there's an imbalance in the values that have transferred, that's where the IAHT problem with the wife's estate as a consequence of the transfers has reduced. And that's the test from an IAHT point of view, is has there been a transfer of value out of your estate?
Okay.
So if it's broadly equal, or there's a cash payment that equalises between the two, you don't run into a problem. But if it's not being structured properly, or they've kind of said, well, okay, we're not bothered about equalising, we'll just do this, then potentially that's where issues do arise.
Okay, interesting. There's a whole, I mean, there's a whole additional question about wills and so on. So we don't have a wills and probate lawyer in the room, but how important is it to relook at your will when you're getting separated or divorced, or once you have separated or divorced?
I think it's really important. We advise all new clients, with our initial sort of follow-up after seeing a new client, to speak to a wills lawyer to update their will, even if they just, I think sometimes they call it a holding will, so they might just temporarily amend their will just to cover the period from separation until divorce, and then once the divorce has come through, they might then revisit their will at that point and readjust it again. But yes, I think it's really important for people to turn their minds to that, not just at the point of the divorce, but at the point of separation.
Yes, there's so much going on, and again, such an emotional time for most people that you need that type of advice to be. I hadn't even heard of a holding will until you've just mentioned it just now, and of course it's a good idea when you're going through transition, which may take longer than you expect, and a highly stressful time.
Absolutely.
Okay, so let's have a look at something else. Right. Now, what about a situation where a husband and wife have their gorgeous family home, and they then have, they part own a property in Spain.
Okay.
And let's say that they own that joint. No, they own that 25% each, and the wife's parents own the other 50%. So when they get divorced, what happens to that part ownership of that property that the wife's parents is probably a little bit gutted about their soon-to-be ex-son-in-law having 25% of?
So I guess from a tax point of view, as soon as we start transferring ownership, we have to think about tax. And if it's a Spanish property, we don't just have to think about UK tax, we've also potentially got to think about Spanish tax as well. So again, going back to the conversation earlier, if it's husband's parents who own the other 50% and wife transfers that 25% that she owns to husband, then depending on the timing that we've talked about, hopefully that's going to be tax-free if it's actually sort of thought about in advance. From a UK perspective, but you've also got to make sure that there isn't any Spanish tax consequences from doing that as well, because whilst the UK may exempt spouse transfers, it's not given that Spain, for example, would exempt spouse transfers from a capital gains tax point of view. And often, property is a classic example where a lot of countries will say, well, if you sell a property that, even if you're a UK resident, if you sell a property that's located in Spain, Portugal, Australia, France, wherever, then potentially you might still be subject to the local capital gains tax on that as well. So it's fine for us to sit in the UK and say, yes, absolutely, if we do it X, Y and Z, there's no tax consequences of this. You also need to make 100% sure that you're not doing something which is going to create a local country tax problem as well. Even if they just decide to sell the property, it may well be that there's a Spanish capital gains tax obligation on selling that property, and as well as a UK tax obligation, in which case then you're into, well, how much Spanish tax is paid and can we offset that Spanish tax against the UK tax that will be payable as well. So as soon as you've got foreign property, it just introduces another layer of complexity and really means that you end up, as you would do frankly in any situation where you're dealing with foreign property, is actually you do need to make sure that you take local country tax advice as well to make sure that the two actually marry up. because it would be rather unfortunate if we said, yes, great, no tax consequences, and then you find, well, actually, yeah, there isn't in the UK, but in Spain you've got a 25% capital gains tax bill, for example. So.
And are there any commonalities, sorry, I'll come to in a second, are there any commonalities with European Union, sort of EU countries, non-EU countries? Are there differences between Spain, Portugal and Ireland, for example?
Every country's got its own capital gains tax system. Some countries don't even have a capital gains tax system, so you can't read across from, if something's the case in Spain, you can't read across in Italy. It's the same with things like inheritance tax as well. So some countries have an inheritance tax, others don't. Some countries have property transfer taxes, others don't.
Okay.
So everywhere that somebody's got a property, you really need to understand the foreign tax or the home country tax, as well as the home country tax consequences of any property transfers.
And does any of this change, and I know the devil's in the detail, we don't yet have the detail, but in October 24, the end of October 24, there's a budget where there were changes to residency rules announced. Will this have an impact?
Most likely not, except if somebody's actually kind of left the UK, but typically even if you leave the UK permanently, then if you sell a property in the UK, you're still subject to UK capital gains tax on the sale of that property. So I don't think the budget will necessarily change things around that, but it would potentially, it changes things like how much is in your, whether you're considered to be fully subject to UK inheritance tax on your worldwide assets or just on your UK assets is going to change quite significantly in that. But in this context, I don't think there's any particular implications, because you're still within the UK capital gains tax net on any UK property, even if you've lived in the US for 20 years effectively. So.
And from a legal point of view, does it add complexity whenever people have assets that are?
Yeah, it's it's relatively common for the kind of cases that we work on, whether there are second, third, fourth properties, and sometimes they are in other jurisdictions, which does throw up not just taxation considerations, but also primarily enforceability issues. So if you get a court order that says a property in Portugal should be sold, that's all well and good, but how enforceable is that court order in Portugal? But back to the taxation angle, I mean, not all clients, but some clients, I think, are resistant or reluctant to incur the costs of this expert evidence, because they probably think they're paying quite a lot of money for legal fees, and they might have a barrister involved in the case and somebody advising on the UK tax. But then, it's vital, as Paul said, to sort of understand the tax implications in the jurisdiction where that property is located, which means another expert is required to sort of do some further work. So that's where the fees can be impacted, but then it's so important.
Well, you get it right. It's
right, exactly.
The cost of not taking the advice can be significantly
and
more damaging.
It's usually fine if we're dealing with Spain or Portugal or France, but if there's property in Southeast Asia or Eastern Europe or India, places like these, it's more difficult to sometimes identify and find the expert that everybody's happy with, who is able to provide reliable information. So
I can imagine, and I can imagine also the process could take a lot longer if the agreement is that something needs to be sold. Then certainly we've clients who've been trying to sell properties in Spain, Portugal and France over the last number of years, and it can be quite tricky because they were easy to buy off plan and whenever those areas were on the up and big investment opportunity, or I suppose often in the case where a divorce maybe happens once the kids are a little bit older, they're no longer wanting or needing to use those holiday homes, and it can be quite tricky to sell.
Yeah, and that sort of delay is something you always need to sort of bear in mind, is how quickly will your client be able to actually realise the asset and have the funds from a sale, or even if it's a transfer, the process can be so slow and take forever, and clients just need to be alive to that and aware that these things can take a long time.
Okay, so let's move from property and talk about business. You know, as an accountancy firm, we advise businesses and business owners and look after an awful lot of them. We're frequently approached by lawyers asking us to do a business valuation because there's either shareholders and owners falling out, or somebody wanting to sell, or in the case of divorce. Paul, how many, percentage-wise, maybe of all of the times you've been asked to do this, how many times have you given a quote and won that piece of work to do an independent valuation?
Not often, if I'm honest, because I think it's not a cheap process. And to Henry's point, sometimes I think people, you know, look at this and think, well, it's just adding to the cost, and you know, but it's so important for us, particularly if we're kind of acting almost as a joint expert and advising both parties, that we've got to do a robust job.
Yeah.
You know, you can't cut corners, and effectively we've got to be prepared to stand behind that valuation in the event that, you know, it is disputed on one side or the other. So.
And I can imagine in both cases, whether it's a marital divorce or a business divorce, the emotions are running high, and one person is going to want the value to be more, and one person is going to want to keep the value down, and
exactly,
it can be a bit of a battle. So.
Yeah, and particularly because, you know, valuations, particularly of a company, is to extent a subjective exercise. It isn't, you know, there's guidelines and there's standard methodologies, but there are judgments that have to be made as to, for example, you know, if we're valuing it based on a multiple of the profits of the company, what should that multiple be? 3, 5, 7, 10, you know, and there's a lot of factors that go into that. And so it isn't just there isn't just a spreadsheet that you can plug the numbers into and it spits out an answer at the bottom. So it is, you know, from our point of view, you know, particularly when it's in this type of situation, it's so important for us to make sure that we're adopting robust processes, but we're using the best available information to make sure that it's as solid a valuation as it can be.
Absolutely, and I'm sure things like directors' remuneration, how they take their money out of the business impacts it massively, because you can't just take a profit line if somebody's taking the bulk of their income by dividend, or I suppose conversely, if somebody is trying to, how do I put this politely, sort of limit the tax, legally limit the tax and their drawings by making massive pension contributions, you know, there's an impact there in the true valuation of the company, certainly for divorce situations. So
I mean, interesting to hear Paul there, because about the subjectivity of these business valuations. And again, a lot of cases I work on and we do as a firm involve a business or an interest in whether it's a family business or one of the spouses has a shareholding in a business. And quite often, if it is a family business, some of the shares will be put in the spouse's name.
Absolutely.
For understandable reasons, and then when it comes to divorce, that can throw up some challenges, because the person who's transferred the shares to their spouse may have done so for tax purposes, not genuinely because they want them to own part of the company, and then when the divorce comes around, it's a different thing. So
can't have it both ways.
Exactly that. So, but also something that maybe Paul could touch on this is one thing we come across a lot is that the income might be received by a director's loan account.
Yeah.
So there's an outstanding director's loan account, which then again the tax implications of that needs to be
absolutely
taken into account.
Yeah. So what we would typically do is, in valuing it, we kind of almost strip out anything that related to what the directors actually take out, and kind of say, well, if this was a standalone company and it wasn't run by its owners, would you need 1 director, 2 director? What would those directors be paid? And kind of adjust the results to reflect what we call a kind of sort of normalised earnings, if you like, if the company was owned by a third party. And then, of course, as Henry says, the director's loan account, typically that is money that's owed to the company if the director's taken money out. So we value what we think the business is worth, so the actual, for want of a better expression, trading activities of the business. But then we adjust that for things like, is there any money that the company's owed, and we treat that as effectively cash in the valuation, and we'd add the director's loan account on top to the valuation to arrive at the kind of whole of company valuation. So you value the business, but then you adjust it for the kind of non-business sort of, for example, debt. If there's lots of cash in the business, we typically add that on pound for pound to the valuation. If the business actually owes the director a lot of money, then we'd knock that off because that's a debt that's owed by the business. So there's a multi sort of level process that you've got to go through, but it does produce, I think sometimes, more often than not, business owners don't have a bit of an idea about what their company might be worth, but typically it's pretty wildly out, and so it can come as a bit of an interesting conversation when you're saying to them, well, this is the methodology and this is what we've arrived at. So again, it's about making sure that you've got the full information and reflecting all of that information in the valuation, but also being able to explain how that has been arrived at as well. Because I think just a bold number, it's £5 million is pretty meaningless, and unless you're able to explain how you've arrived at that figure.
So I know that if we were doing a valuation for, say, a company buyback of own shares, where there might be two directors, shareholders that have fallen out, we need to get clearance from HMRC about that methodology and so on. Is that the same with a valuation for a couple that's divorcing? If they both, I suppose, if they're both shareholders, it would be perhaps, but if they're not both shareholders and it's just a husband and wife, there wouldn't be. It's
a really interesting one. I think it very much depends on if there's an agreed price that is going to be paid for the shares. Again, if it's between husband and wife, then we don't really care what the actual price that's paid is, but often the cash might be in the company that's going to pay for the shares. So in that case, it's not the husband buying, in inverted commas, the shares off the wife, or vice versa. It's the company buying back the shares.
And there's a big tax differential for all parties in that situation.
There is a big tax differential in that situation, because that buyback by the company isn't an exempt transfer between husband and wife. And then you get into, there's lots of rules around if your company buys the shares back. Actually, the default treatment seems curious to say, but the default tax treatment is actually to say, well, that's treated as a dividend for the person receiving the cash, unless this whole raft of conditions are met. And that's where this clearance application comes in. You essentially go to HMRC and say, we meet all of these conditions, so it can be treated as a capital gain, rather than, so you're potentially paying 10% or 24%, as opposed to if it's treated as a dividend, you could be paying 38-39%. But the buyback is often the way that we end up doing this, because if there is a cash settlement, a lot of business owners, all of their cash is tied up in the business because they've only taken £100,000 a year to keep themselves below a tax threshold. They're not cash rich themselves. They're having to use the cash in the business. So if they had to take that out, if wife had to take that out to buy the husband's shares, the sale of the shares would be capital gains tax free, but the taking the money out would be subject to income tax as a dividend or a salary. So it can start to get into some real nitty gritty tax issues in making sure that structure is actually approached in the right way, and you are ticking the right boxes.
Wow, right.
to get the best tax outcome.
Thank you. So looking at that's a situation where the company is cash rich and the company has the money there to buy back, because again there are rules around that.
Absolutely.
It can't be a loan, it can't be further down the line, it must be immediate, all the cash must be there. What in a different situation, again I'm sure, Henry, you come across businesses where perhaps a lot of the value of the business is tied up in assets. They might have a premises from which they trade. They can't just sell that premises to give the spouse half of the value. Is there any way that how would you go about working that out if there's a huge value but there just isn't the cash?
Yeah, I mean, liquidity is often a problem for because it's all like you've just exactly said, it's all very well and good saying, well, the business is worth this, but how is that money extracted, or how is that value extracted to settle a divorce settlement? It does present a challenge, and you know, the family courts and the district judges who deal with this area of law are experienced, and they realise that, I mean, they're quite commercially minded, and they realise that a valuation in a report is one thing, but how do we extract the cash and, you know, realise that into money to be able to pay the spouse what he or she is due in the settlement, and it, you know, that can have an impact on the true valuation, I suppose, in that it's not just the on paper valuation, it's how that money is extracted from the business, if it has to come from the business, or where else can it be raised from.
And can it be paid over a longer period of time, or
yes.
is that just another angle to negotiate between two parties?
It's a negotiable point, but yes, you can have, if it's a lump sum, for example, it can be payable as a series of lump sums.
But the tax treatment would be from, you know, so if, for example, this was over 5-10 years, you wouldn't have a 3-year run out. It was agreed here, and
so I mean, again, if it's just husband and wife, then we don't need to worry about it. But if the gain's going to be taxable, if it's a fixed amount but it's just payable by instalments, then effectively from a tax point of view, you treat it as if you had the cash on day one.
Mm-hmm.
You can ask HMRC to pay capital gains tax in instalments, but I think I've had one instalment request approved by HMRC over the years, so they're not terribly generous around that. So you are in a situation where if it's spread over a long period of time, then those initial instalments might all be eaten up just paying the capital gains tax if there is actually a tax charge on it. So,
what other watchouts would you say there are, Henry, whenever you're dealing with family businesses and sort of that type of asset between spouses?
I guess it depends which side of the fence you're advising. So if you're advising the business owner or the non-business owner.
Let's say they're both business owners, they both own the business, whether they both do the same amount of work in the business, but if they're both owning the business.
That's can be difficult, and you know, I have dealt with cases where they've agreed to carve out the rest of the assets but continue to run the business together. If it's a successful business and they both invested and involved in the day-to-day running of the business, and it produces a good income for them and hence a good lifestyle, they might be keen to sort of carry on with that regardless of the fact that their marriage is broken down. So that's not hugely uncommon, but where one wants the other out of the business, you know, that is a difficulty. If they both want to stay but not work together, then there's got to be a solution, and that can sometimes be
big offices.
Well, yeah, that can sometimes be a case where you might need the court's involvement, because if there's just deadlock and people just can't agree, then it falls to a judge to decide, and they would have to decide, you know, based on all the evidence. And I mean, usually there's a compromise to be reached at some point, and there's always a value or a number that somebody might be willing to sort of walk away with. So
I suppose this is where having a robust shareholders agreement from day one, even if you are a married or cohabiting couple, is just so important, because then you can you make these agreements whenever you're friends and whenever you're happy and whenever everything's going well, and then you can refer back to that, but you've both agreed this is how the valuation will be done, and this is what will happen if we can't come to an agreement.
Yeah, I've lost count of the conversations. You know, you should have a shareholders agreement. We're all friends, yes. Well, you're friends until you're not friends, and it, you know, what's the old expression? You know, you fix the roof while the sun's shining. You set out the parameters.
Well, it's like an insurance policy. You can't really buy a home and have a mortgage without an insurance policy. So, you know, you should be doing the same with your business and your greatest assets, I suppose. There are so many more questions I could ask about this. Actually, here's one that on both property and businesses, and I think just because I saw something on LinkedIn this morning, and it was a will writer, I think, that was talking about the fact that there is no common law spousal legality in the UK. So if you have two people that have been living together and have 5 children together and both own the business together, but aren't actually legally married and both own the home together, then it's a whole different kettle of fish from a tax point of view. Is that?
Yeah, absolutely, from a tax point of view. And I mean, it seems absolutely ridiculous in this day and age that you still got this distinction between people who are married and people who have been living together as if they'd been married for 20 years and had multiple kids. But yeah, effectively, there is no concept of, you know, a sort of a tax-free spousal transfer in a situation where the partners aren't married.
Mm-hmm.
If you've got a civil partnership, then yeah, absolutely that falls within the rules. But if you are just cohabiting, you're not actually legally married, then if you transfer assets from one spouse to the other, then the tax rules basically say that that's a deemed sale at market value, and you get a totally different treatment than somebody who, you know, has walked down the aisle, you know, 20 years ago, but otherwise has had exactly the same relationship, which, you know, frankly is a nonsense. And you know, as unromantic as it sounds, sometimes we are actually having conversations with people to say life would be so much easier if you actually got married from a tax point of view.
Wow.
Yeah.
Wow.
So.
And do you come across any, do you have people that contact you, Henry, and say, look, this is a situation, we're not actually married, but we want to get divorced?
Yeah, I mean, similar to what Paul was saying, the law surrounding cohabiting couples is completely different to married couples. This concept of common law wife or common law husband is just not a thing. It's a myth, and the law is so different as it stands. I think there is lots of pressure, which I think will eventually tell, but there is a lot of pressure for the law to change and catch up with modern society. But as it stands today, you know, it's so different, the law, that there can be scenarios, and you know, I've seen clients who are not married, they're not happy in the relationship, but the other person doesn't necessarily know that, and the advice mine will be get married, because you'll stand a better chance in terms of financial settlement.
Oh golly, that's like having a kid to patch over a bad relationship.
Well,
but wow.
Because importantly, the you know, you could be in a non-married relationship for 20 years and then get married for 1 year, and then the marriage breaks down, but the divorce courts would see that as a 21-year.
Right.
Oh, they would,
marriage,
despite the fact that they didn't see the 20 years.
So the
That's
pre-marriage
interesting.
cohabitation is sort of bolted onto the length of the marriage, so to speak, which can be a really important factor in how the assets are divided.
Wow, that's new news to me.
You do. I mean, you feel a bit cynical saying these things to clients, but you know, the financial implications of being married or not married can be so. I mean, for one example is you don't qualify for any sort of pension share if you're not married. You know, it just can't be done. So you could be in a 30+ year relationship and not married, and your partner has a huge pension fund, and you have zero claim over that pension fund.
Gosh.
Whereas if you've been married, you're potentially getting 50% of it, so it can make a big difference.
Wow, I'm kind of shocked with the can of worms we just opened there. But you give me a perfect segue by talking about modernisation of the law and tax, and something that we've seen a lot of recently, and it's on the increase again. And since Mr. Trump was re-elected in the US as president-elect, we've seen cryptocurrency go through the roof in terms of valuations. And I'm sure it's just this week that there's been, is it Andrew Tate has been brought to justice over his cryptocurrency gains that he owns, owes HMRC maybe 22 million or something like that, not quite sure. But we've done a little bit of work around cryptocurrency. We've got a few videos on that from some time ago, because people just don't seem to understand that cryptocurrency gains are capital gains. It is an asset, and it's an asset that sometimes people will play with, will gamble with, will invest in. They will see huge gains. They will take that money out, whether that's literally taking it out and transferring it into sterling, for want of a better term, or actually reinvesting it in a different cryptocurrency. That is, you know, that is the opportunity for that to be taxed. So what happens in the divorce situation if somebody has a crypto asset? Because we can see how, you know, how things can grow and fall and grow and fall, and it's not something that has a very fast and stable valuation for one thing, and then the tax implications are another. So to you first then, Henry.
Yeah, exactly. I mean, we're seeing, as you'd expect, more and more cases where crypto is an asset to be considered, and it's in its simplest form. It's an asset in the same way as cash in the bank would be, or an ISA or whatever. The challenge sometimes can be to establish the true value, not just the gross value, but the tax implications of it as well.
And which date? What date do you take?
Well, you would take it as up to date. So if you're trying to negotiate a settlement, you would want to establish what the value of the crypto is at that point. Now, you make a good point in that it's amazing how often the person with the cryptocurrency is very keen to say, oh, actually, the value's plummeting, or it's not worth, and they try and just sweep it under the carpet, and it's not worth anything, or it's very volatile. But no, you would take a snapshot at the time you are trying to negotiate a deal and take the value as it is then. But again, the tax implications is something that, again, we're more and more increasingly having to sort of turn our minds to, whereas it might have been you know, a fairly low amount of crypto that, you know, that wouldn't offer really feature much. We're seeing it more and more as more of the larger assets, you know, to take into account. But in terms of the tax implications, then
it's over to Paul.
And
Paul, if you would just touch on that, because the things that we've seen in terms of it, without good record keeping, it is absolute nigh on impossible to properly calculate. There are a lot of people that really play at this and think that they can just move things around and not actually, you know, keep record. But every time you move something, that's a trade and a gain or a loss.
Yeah, I think that's absolutely right. I think, I mean, being honest, HMRC probably didn't help things right at the start of crypto, because they kind of equated it almost to gambling. And you know, you don't pay tax on the profits of gambling, but over time they've realised that actually, do you know what, this is actually, you know, more than this. I think the point to be aware of, and I think you touched on it, Sarah, is that for the vast majority of people, they might see themselves as a crypto trader, but from HMRC's perspective, they're capital gains tax assets, crypto. So people will, strangely enough, they'll try and argue that they're a trader when they've made a loss, because they want to be able to claim that loss to offset against their other income. But HMRC will almost always say, you know, that you are actually, you're doing this as an investment activity. So when you realise, you know, if you convert Bitcoin into Dogecoin, then you're selling one asset, which is Bitcoin, and you're buying another asset, which is Dogecoin. So you've got capital gain on the sale of the Bitcoin at that stage. You're right. I mean, I think a lot of the platforms now are much better at keeping the information that's needed to calculate the tax. But it's a massive problem area generally, and then I guess if you overlay divorce on top of that, then it just creates another world of complexity. But fundamentally, as Henry says, it's treated in many ways from a tax point of view as any other capital gains tax asset. So again, you know, going back to the rules we were talking about before, spouse transfers, provided they meet the criteria, doesn't matter what the valuation is from a tax point of view, there's no gain. But if you fall outside the spouse transfer rules and it's not exempt, then you've got to look at the value at the day that the crypto is transferred, and there's either a taxable gain or a loss that arises from a capital gains tax point of view when the asset is transferred. And again, in a typical, you know, in that situation, you might have a very substantial capital gain, but you ain't got no cash to actually pay the tax. And you know, I mean, just crypto generally, we've seen people who've made huge gains ended up with massive tax bills, promptly then lost everything, and have been made bankrupt because they haven't got two pennies to rub together in order to pay the tax bill. Yeah. So, you know, the whole volatility of it just creates a massive issue, and divorce just adds an extra layer of complexity in terms of that. You know, are we paying tax on the gain or not? If we're paying tax tax, have we actually got the cash to pay the tax?
And what happens later?
Yeah.
So, out of interest then, and just something you said has made me ask another question, is, so are crypto assets in terms of gains, are they ring fenced, or could a loss in cryptocurrency be offset against a gain in your Shopify shares that you've bought?
Yeah, absolutely. So it is a capital gains tax loss. So
you could, so if you had, I don't know, a few watches, so physical assets that you could sell for a gain, and you make money there, but you lose money on your crypto, you can offset one against the other.
Exactly that.
That's interesting.
Yeah. But what you can't do is offset that loss against income.
Yeah.
So it's only capital gains.
Perfect. Thank you. I'm gonna go back to come out of the future of crypto assets, so to speak, and back to property a little bit, and but specifically, again, post-budget 2024, anybody who's listened to the news cannot have avoided hearing farmers talk about agricultural property relief, and small holdings and business property relief and so on. Henry, what happens if you have a husband and wife, a farming couple that come to divorce? I can't begin to imagine how much complexity there might be there in terms of not only assets, but input and ownership, and maybe other things that they have around that.
Yeah.
And again, the cash impact or liquidity, as you.
So farming cases are almost always a challenge because very rarely is the husband and wife the only shareholders in the farm. Usually the farm was passed down through sometimes 2, 3, 4 generations. So, and some of those generations might still be alive and still have an interest in the farm. So not only does farming cases present problems in terms of who owns what, but also this is more of a legal point perhaps than a tax point, is that the fact that the farm was passed down through generations can open up an argument for the to say that, look, this isn't a matrimonial asset as such, in that we haven't bought this farm together as a couple, it's inherited, so it shouldn't be shared in the same way as an asset that we've accrued as a couple. So
that's interesting. I didn't think that could happen, because I'm certainly seeing people where one individual's maybe bought a property that before they meet the spouse, and then the spouse moves in, but certainly that's considered
I think
equitable
in that situation, if the spouse has moved in and it's become the family home or the matrimonial home, then the lines are much more blurred, and a court is more likely to say, well, hang on a minute, yes, it was owned pre-marriage, but it's become a joint asset.
Surely it's the same on a farm?
Yes and no. I mean, I think just because it's so easy to clearly identify where the farm has come from.
So it's almost lineage.
Exactly that. So even before you start having arguments about liquidity and tax issues, the principle of should this, or the farmer, should his interest be shared equally with his wife, you've got this first layer of argument to say, well, you know, it's a non-matrimonial asset, it's been acquired through inheritance effectively. Do we treat that in the same way as if it were an asset that had been accrued? And almost always the answer is no. But then the sort of the farmer's wife, without being stereotypical, you know, also has other arguments such as needs and, you know, being able to purchase a property for her and sometimes the children to live in. So all these legal arguments are all well and good, but, you know, needs trumps everything else. So if there's a financial need for a share, then you would get that. So, but yeah, sort of the origin of the farm creates a problem before you even got into ownership structures and taxation issues and liquidity issues as well. So they are difficult cases.
Yeah. Okay. Paul, do you want to talk to me about tax impact currently, and then tax impact in 3.5 months' time?
Yeah, I mean, I think it's from a capital gains tax point of view, it's very much the same conversation. But if you don't get that tax-free spouse transfer, then the question of whether the assets qualify for, as a trade. So quite often people will own farmland, but they don't farm it themselves. They might actually, effectively just let the land to to another farmer who farms it on their behalf. Now, from an inheritance tax point of view, that asset could still qualify for agricultural property relief because you don't actually have to be actively farming the land yourself. But in terms of some of the capital gains tax reliefs, to be able to transfer land outside of a spousal relationship tax-free, that can have an adverse impact because it's not used for trading activities. So as soon as you start trying to divide up farmland, there's a whole layer of complexity around the capital gains tax, the interaction with the inheritance tax rules even now. But then when you project forward to when the rules change and the agricultural property relief is going to be restricted, then I think Henry talks about sort of net value of land, and are we going to get into arguments about, well, actually, there's almost a latent inheritance tax liability on this land down the line. I don't know.
And the tax implications are huge.
Yeah, I think it's particularly because I think most farms are still held as partnerships because it's much easier from a succession point of view to sort of transfer the ownership, or through a partnership route than through a company. So you're then into looking at what people's capital accounts are worth. You're looking at who actually beneficially owns the land, because although it might be partnership property, it might only be two partners who've actually got an interest in it. Are they the two parties who are getting divorced, or is it mum and dad? And from a tax point of view, it just opens up a massive can of worms in terms of those asset transfers, really. So farms are amongst the most complicated businesses, not only, as it sounds like, from a legal perspective, but from a tax perspective as well.
Mm-hmm. Blimey, minefield, I think, to unwind there. I'm sure that would keep you both busy. What sorts of questions are not asked, Henry, that you think we should be touching on when we're looking at the implications of tax and divorce, or just the things that, maybe what are your top 3 to 5 things that you think everybody just should have front of mind whenever they're considering a separation, because it's a very stressful time for people?
Yeah, I mean, it is a stressful time for people, and as I said right at the start, I think just the tax or potential tax implications of what they might be looking at can be so important and can sometimes get overlooked, and that, as a lawyer, makes us go cold because we don't want clients coming back in the future saying, hang on a minute, I didn't realise there was a big tax charge here or whatever. So it's important that we get it right early on in the process. But really, it's the capital gains tax, whether that be in relation to second homes, third homes, whatever it might be, shares,
foreign properties,
yeah, the jurisdictional considerations as well, of the different tax rules. So it's everything really, and part of our there's 2 sort of stages when you're dealing with a divorce in terms of the finances. Is firstly, what's in the pot, and secondly, how is that pot divided? Well, phase 1, the sort of discovery phase and the valuation computation stage, almost always involves some tax consideration to get to the point where you are confident, and the court is confident, that the actual asset schedule we're working from, negotiating from, is actually true and accurate. So that's where somebody like Paul is invaluable to our role and adds value to our clients from that perspective. So yeah, it's really important.
Okay, thank you. Paul, any last words, any sort of guidance? Or?
No, I mean, I think from our point of view, it's getting involved as early as we can in the process, I think, but working with Henry and his team, for example, just to make sure that we're kind of involved on an ongoing basis, I think, because it is very, very easy. I mean, our clients overlook tax at the best of times, let alone at the worst of times, as far as divorce is concerned. So I think it's, just understanding those implications, but not letting those implications drive the decisions. I think that's the other point, really, just to go back to what we were talking about before. work out what's right, understand what the tax looks like. Is that level of tax acceptable? If it is, crack on. If it's not, let's tweak it. But you know, it's not a case of saying what's the structure that will, or what's the split that will achieve the lowest possible tax charge, because I think that just, as I say, you may get a short-term benefit, but it feels like you're actually potentially setting yourself up for you know, significant problems into the future. So tax is an unavoidable consequence of any transaction. If you can manage it as best as you possibly can, but don't let, you know, it's the old cliche, don't let the tax tail wag the sort of personal or commercial dog, really, I think.
Yeah. I thought you would never say that on camera, Paul.
I was finally forced in.
It's very true, though. It's very true. Henry, how can people contact you if they need guidance and support?
They can go on our website, which is family-law.co.uk. All our contact details are on there, and then the usual socials such as X and LinkedIn. All the solicitors at Maguire Family Law have a LinkedIn profile,
Fantastic.
as does the firm, so we can get hold of us that way.
I'll pop some links to that into the article and the video. Brilliant, thank you very much. Thank you.